All right, y'all. Let's get a little music going. All right, all right, all right. How's everybody doing this evening? Let me go and get me a bottle of water, y'all, and then we'll get to the case. Is this the right case? Is this it? This one is a good case too, but I pulled up another case. I think it's a Mississippi case. Yeah, I did. Pulled up another case. All right, we're gonna read this one. This is the one I'm gonna read tonight. So I'm gonna read this case, go over it, and then I'll take, we'll do some Q&A. Let me put the number into the chat. Well, it should already be in the chat, come to think of it, but I'm gonna put it in now anyway. How you doing, Gary? That's the call-in number, but I'm gonna go ahead and let me go get me a bottle of water, and then we'll start on the case. Give me about 20 seconds. Be right back. All right, all right, all right. All right, before I begin, I'm gonna ask, I gotta make sure everybody can hear me. Can everybody hear me on a scale of 1 to 10? How good can you hear me? And if you haven't, please go ahead and hit that like button. Also, go ahead and register to sign up for my jury membership. I can't even say the word, but jury membership. It is 99 cents a month. I really appreciate that. Can y'all hear me before we begin? Before I start reading the case, I want to know how good y'all can hear me. Got the microphone in. Give me a number, 1 to 10. How good can you hear me? Oh, boy. When you call into the show, just press 1. I'm not taking calls right now. Okay, I'm not taking calls right now. I'm gonna read this case, and then we can build from there. And if you have any types of questions that are not relating to the case, that's fine. We can talk about it. I don't care. Uh, all right. So I'm assuming you can hear me, Gary. All right. It says let's do it. All right. So I'm gonna go ahead and start, and let's get this case going. This is a Mississippi case. So let me go back. I was just doing some research, y'all. Let me show y'all what I've typed in. All right. This is the website that I use. Uh, this is the old website, but it's still up and running. It's called old.case.law. All right. So what I put in, because this right here, what you're seeing right here, this is a search engine. All right. So I typed in municipal corporation, territorial jurisdiction, tax, private property, taking, due process, just compensation. All right. That's what I typed in. And this is what I got. I read this case here a couple of days ago. This was a really good case too. But I think this is the case we're gonna read. I think Martin versus Dix. Let me see if that's it. Yeah. So it's right here. We're gonna read this case. But I'm gonna see if I can add the it's probably too much for me to type and add in there. I'm gonna see if I can do it. Give me a second. Let me go back. Okay, it'll work. All right, this is the case citation. So I'm copying and pasting the case citation for y'all to read. If y'all want to read it, all right. I'm putting the case citation in the chat. That's the case citation. So if you click that link, the case is gonna pop up. And if you want to read the case, when you click that link, you would do let me go back. you would click this right here. See this PDF? You would hit PDF, and a PDF file of the case is going to pop up like this. I just hit PDF, and boom, here's the case right here. You can save, if you wanted this case, you can save it onto your computer. All right, let's go back. This is a case from 1876. All right, I haven't read this case. It's new. I'm going to read it right here. All right, but this is a Mississippi Supreme Court case. This is why I say it is our fault, because there is no excuse for us not to know our rights. And this case is this old. This case is, let me see how old this case is. This is 2024, allegedly 2024 right now. Let me see how old this case is. So 2024. This case is 148 years old. I know everybody listening to this video now and in the near future is not 148 years old. So there's no excuse for us not to know this. All right? No excuse. All right? Let's get to the case, y'all. Let's go ahead and get to the case. All right. So let's see. Appeal from the Chancery Court of Adams County. So a Chancery Court is an equity court. And they don't call them judges in there. They call them chancellors. That's why this term right here is chancellor. So the so-called judge in this case, or would be the chancellor. The facts in this case are very fully stated in the opinion of the court. The following errors are assigned. So that this is an appeal. They appealed it. The court erred in sustaining the demur. A demur is an antiquated euphemism for dismiss. Sustaining the demur and dismissing the bill. Bill, what bill are they talking about? They're not talking about a light bill. They're talking about a bill in equity. In equity, they call it a bill in equity or a bill of complaint. That's what they call it in equity. In sustaining the demur and dismissing the bill on rehearing, Martin versus Lanier versus the appellate would be Martin, okay? And Dix would be the tax assessor in this case. So the appellee would be Dix, and the appellant would be Martin. I think his last name. Well, yeah, Martin. Whatever. All right. The facts bring the case within the jurisdiction of the court, and then they're citing all these cases. Our own Constitution, Section 2, Article 2, Section 10, gives to the citizen the same protection. Taxes are assessed and collected for the benefit of all as a necessity. So in other words, what this means is a tax is conditioned on a benefit, unless you just want to willingly give it to them, because you can give them something of value in exchange for nothing. You can do that if you want to. You can do that to anybody. Complainant would be, which would be Mr. Martin, derives no benefit from the tax extension. I mean, from the extension. On what can the city base its right to tax him? This is a question, because there's a question mark. Recently in Missouri, Iowa, and Kentucky, the Supreme Courts of those states have decided against the right of the legislature to subject to arbitrary taxation real estate. Let me go back. I think I might have read that wrong. Recently in Missouri, Iowa, and Kentucky, the Supreme Courts of those states have decided against the right of the legislature to subject to arbitrary taxation real estate, lying beyond the reach of the municipal benefits of a city. You see that? These go hand in hand. So if they're taxing you in exchange for what? Unless you're voluntarily giving them this. In the cases of flagrant injustice, the courts will interfere and control the limit and the taxation power when it ceases to operate beneficially to the proprietor in a municipal point of view. Dillon versus, like, all of the, where is it at? Dillon, in his work on municipal corporations, that is like a treatise for the powers of municipal corporations. That's what that is. Dillon, in his work on municipal corporations, page 74, section 634, volume 2, sums up the result of the decisions, and adds to the authorities. Iowa, blah, blah, blah. This is an Iowa Supreme Court case. I'm assuming an unlimited power to make any and everything lawful, which the legislature might see fit to call taxation, would be, when plainly stated, an unlimited power to plunder the citizens. In any case, the judge or justice, being free from the doubt in his own mind and unfettered by any judicial decisions properly bearing upon him, must follow his own sense of duty upon constitutional as well as other questions. All right, so that's what he's made. That's his argument. All right. Now we have the appellee. The appellee would be the tax assessor. So this is an attorney, I'm assuming, for the tax assessor. And of course, they're going to make one-sided arguments, just like you make one-sided arguments too in your case. But it's up to the chancellor in this case to decide this case. If the legislature had the constitutional power to pass the act of April 17, 1871, extending the corporate limits, then the former charter and ordinances applied as well to the newly embraced parts of the corporation as to the old, and that's part of their argument. So that what they're saying is that they have the authority to tax him. That's what this is all about. That they have the authority to tax his private property. The legislature possesses all legislative power not prohibited. Its power is limited only by its own discretion. Let's go. The clause of the United States Constitution referred to has no application to the states. I remember this case. Barron versus City of Baltimore. That's a Supreme Court case right there. That's where they get that authority from when somebody tried to sue out of Baltimore, Maryland, and they tried to use I think it was a state citizen. He sued in federal court, and he tried to allege that something the city did. They took his private property without just compensation. He tried to argue the Fifth Amendment, and at the time, the 14th Amendment had not been allegedly ratified. All right. So this was prior to the 14th Amendment, and so they held that that didn't apply to him. The Fifth Amendment didn't apply to him. It applied to the federal government and not the states. That's what they held in that case. I remember that case. The provision in the Constitution of Mississippi that private property shall not be taken for public use without just compensation, Article 2, Section 10, is a limitation upon the exercise of the right of eminent domain. So what we have here in this case, y'all, is we have a private citizen, all right, that has a dispute with a public citizen, a municipality, a municipal corporation, a corporate citizen. So he's arguing that his private rights are being infringed on in a manner that is inconsistent with the Constitution. And the municipality, the corporation, municipality is arguing that their public rights, that they have a public right pursuant to some charter or some statute that they were given by the legislature to levy a tax on his property because it is within their corporate territorial jurisdiction, or that they got it in a manner that was consistent with the principles of equity, something like that, or consistent with the principles of due process. It's going to be one of those type things. Is the limitations upon the exercise of the right of eminent domain, and relates to that subject alone. The legislature may create municipal corporations at will from its own view of necessity without consulting the parties interested. And then this is all of their authorities right here that they're citing. The legislature may annex territory to a municipal corporation, meaning, in other words, the legislature may seize territory to a municipal corporation without the consent and even against the remonstrance of a majority of the persons residing in the corporation or on the territory to be annexed. So he's saying that they're arguing that they have plenary power to just seize. No, they don't. No, they do not. They don't. I've already showed you the cases that show you that they don't. So let me go back. Let me go back and let me check the chat right quick to see what's going on. All right, sounds good here. Okay. Y'all make sure y'all hit that like button. Do me a favor, hit that like button. Let me get a drink of water, and then we'll get back to this case. Jay, what was it? Jay Chalmers delivered the opinion of the court. Let's make this a little bigger. All right. Oh, sorry about that, y'all. Where we at? I think it's up here. Right here. Yeah. The bill is filed, the bill in equity is filed to enjoin and restrain the collection of a municipal tax assessed against and claimed to be due by complainant to the city of Natchez, Natchez, Mississippi. It alleges that complainant, which would be the appellant, resides resides in the country at a distance from the city of Natchez, and that his residence was there fixed with a view to the enjoyment of the pleasure of the country life, and to avoid the dust and noise, as well as to escape the burdens of taxation incident to the city life. So if you're moving into the city, you want to enjoy the city life, you know, you want the benefits of all of a McDonald's. You want to eat McDonald's every day, or your favorite restaurant, or want to go to a movie. All of these are benefits. All right. And as a result of these benefits, you don't have to pay taxes on it. You want to enjoy your roads, nice clean roads, paved roads, stop signs, stop lights, so on and so forth like that. Okay. Okay. You can enjoy that. We'll give you these benefits, but in exchange, burdens of taxations will be assessed against you. What did I go? And to avoid the dust and noise, as well to escape the burdens of taxation incident to the city life. That his residence and property is that his residence and property is more than a quarter of a mile distant from the incorporated limits of the city, as the same have been established and defined for a great number of years, but that on the 17th of April, 1871, the charter of the city was amended by act of the legislature, whereby the boundaries of the city were extended 1/2 mile in all directions, save on that side of the city washed by the waters of the Mississippi River. That by this enlargement of the city limits, the residents and lands of complainants were embraced therein. So they're attempting to annex his private property into their corporate territorial jurisdiction, and as a result, they're also trying to tax him for it. Let's see if he acted in a manner that is consistent with the principles of equity to give him his remedy. I don't know. I haven't read this case. It is charged that this change in the corporate limits was unnecessary and uncalled for by the wants or wishes of the inhabitants, either within, meaning within the corporate territorial jurisdiction, or without, meaning outside the corporate territorial jurisdiction, either within or without the old limits, and was dictated above all by a corrupt desire to city taxation the property situated in the country contiguous thereto. I can't pronounce that word for nothing, y'all. It is alleged that the city of Natchez has been steadily declining in population and business for the last 15 years, with every prospect of a continuance in such decline. That there were, previous to the enlargement of its corporate area, very large bodies of land embraced therein, which were wholly unoccupied by streets, houses, or squares, and these unoccupied portions are increasing rather than diminishing. It is represented that complainant's property is wholly used by him as a residence, with the usual lots, orchards, gardens, and yards property. And yards properly, what is that? Appertaining to a country home, Not a city home, a country home, and that the portion not so occupied is a cotton farm, and that no part of it has ever been mapped off or platted by him into town lots with a view to each, let me see, with a view to sale as such, nor does he contemplate such action, I'm sorry, that his residence is 600 yards distance from any street and 1 mile distance from any police station, fire engine house, or gas lamp, so that he has not received, see that? He hasn't received any benefit of that. Is this making sense for y'all? He hasn't received any benefit as a result of them taxing him. Let me go back to the chat and see if this is making sense. They were selling the land back in 1796. The Northwest Territory federal land, 1875, was the way to make township by sale the land. U.S. Okay, so we got. Hit that like button for me if y'all don't mind. This is a good case. Let's get into it. Where do we leave off? I'm gonna go back up here. It is represented that complainant's property is wholly used by him as a residence, with the usual lots, orchards, gardens, and yards properly appertaining to a country home, and that the portion not so occupied is a cotton farm, and that no part of it has ever been mapped off or plated by him into town lots with a view to sale as such, nor does he contemplate such action. That his residence is 600 yards distance from any street and 1 mile distance from any police station, fire engine house, or gas lamp, so that he has not received, and in the nature of the things cannot receive, any benefit from the municipal government, save perhaps the right to vote in charter elections, which he freely disclaims and would gladly surrender. It is shown that the municipal taxes assessed against him are $225, and the prayer is that their collection is enjoined. There was a demur to the bill for the want of equity, which was sustained, and the bill dismissed. So they're saying he's not entitled to an equity remedy. That's what they're saying. I don't think so. I think he is. We're gonna see. Because based off what I read so far, it seems like he's entitled to a remedy in equity. Complainant's bill is based on the idea that while it is what is that? Oh, okay. Complaints bill is based on the idea that while it is competent for the legislature to incorporate cities, which is it is, and towns, and to fix and define their boundaries, such legislative action must be confined to the bona fide exercise of the power. He is absolutely right. And that it cannot, by an arbitrary and causeless or corrupt abuse of the power, declare that to be a portion of a city or town, which in fact is agricultural land, wholly disconnected with the city and in no manner needful or useful of its government or its occupation. It rests upon the assumption that such legislation is unconstitutional, it is unlawful, it is unreasonable, it is patently unlawful. It's a violation of due process. If not to the full extent of rendering the extension of the city limits nugatory, at least insofar as it seeks to authorize the imposition of municipal taxes on the property improperly embraced. Such taxation is said to infringe that clause of the Constitution of the United States, which provides that no person shall be deprived of life, liberty, or property without due process of law, nor shall private property be taken without just compensation. It is also said to be obnoxious to the like provisions in our own Bill of Rights, and also to the 10th clause of said instrument, which provides that private property shall not be taken for public use, except upon due compensation first being made to the owner or owners thereof in a manner to be provided by law. So far as the clause quoted from the Constitution of the United States is concerned, it is well settled that it is a limitation upon the power of the federal government alone and does not apply to the several states. So what we're talking about right now, this is before, like I said earlier, before the 14th Amendment. This is before Mississippi became, I'm guessing, a political subdivision of the federal government. That's what it seems like to me. Give me a second, y'all. I'll be right back. Let me see if you're coming down. I know the AC might be frozen. Almost ready. I'm gonna give it about 10 minutes. It's almost ready. I know, but it's almost ready. All right. Let me get me a drink of water, y'all. Okay. The inhibition in our Bill of Rights against the deprivation of property, except by due process of law, doubtless applies as well to the legislative as to the judicial departments of government, but in a much more restricted and wholly different sense. As regards judicial proceedings, and as applicable to private controversies, it means that citizens shall not be divested of his property. It means that the citizen shall not be divested of his property except after some legal inquiry conducted according to the forms of procedure established by a general law, applicable to a class of cases in which the particular case may be said to fall. With regard to the legislative department, it certainly means that everything shall not be taken as a law merely because it has passed through the forms of enactment. Did y'all see that? Man, look. Let me check the chat right quick, man. This is why you got to go and read old cases. This is our fault, y'all. It's our fault. Got to go and read these old cases, man. You got to go and read them. All right. Let's get this going. Where we at? Right here. With regard to the legislative department, it certainly means that everything shall not be taken as a law merely because it has passed through the forms of enactment, and that it is, therefore, incomplete for the legislature, not incomplete, incompetent for the legislature by acts of attainder or bills of pains and penalties or of confiscation or in any other mode to take one man's property and give it to another or transfer it to the state. It does mean, however, that the validity of a law is to be tested by any form of procedure other than those prescribed in the Constitution for the enactment of legislation, but rather, hold on, did that mean? Yeah, okay. But rather by the general principles of civil liberty and constitutional power established by the organic law. Due process of law, therefore, will in each particular case mean, as applicable to legislative acts, such exertion of the legislative will as is sanctioned by the settled maxims of our jurisprudence and not specially prohibited by the Constitution. Whether this provision applies at all to questions of taxation, and if so, to what extent is most is most ably and exhaustively discussed in the case of Griffin versus Mixon. See that? This is why you got to go and read old cases. I think I'm gonna go and read that case. Not today, but I'm gonna read that case. I need to highlight that. Give me a sec. I gotta highlight that. So I'm gonna highlight that. Put that in there. I gotta go and read that. both in the opinion, both in the opinion of a majority of the court and in the dissenting opinion of Mr. Justice Handy. We must say that we think the views announced in the dissenting opinion better supported both upon reason and authority. However, this may be, it is impossible to see how the mere annexation of complaints property to the city limits can be said to violate the clause of the Constitution under consideration. Whether the mode of taxation therefore adopted by the municipal government would fall beneath the condemnation of the clause could only be ascertained by a consideration of the machinery devised for its enforcement. There are no complaints nor allegations on this subject contained in the bill. We cannot hold that the mere extension of the city boundaries and to the consequent liability. Let me go back. We cannot hold that the mere extension of the city boundaries and the consequent liability to municipal taxation thereby imposed upon complainant's land constituted a deprivation of his property without due process of law. Okay. Are these acts liable to the reproach of are these acts liable to the reproach of taking private property for public use without just compensation? This provision of our Constitution is contained substantially in those of every state in the Union and has been, the subject of repeated adjudications. While the decisions are to some extent conflicting, we think the better view is that it has no reference to the taxing power of the state, but to the exercise of the right of eminent domain. Now, I've seen cases that are a little contrary to that, which is why they say why the decisions are to some extent conflicting. So I see exactly why they said that because, like I just said, I've read cases that they consider it a taking. Let me go and check the chat right quick. All right, so let's get back to it. Let me go and check the phone line. I haven't even checked the phone lines. Both of these great fundamental powers spring from the sovereignty inherent in every independent government, but they are quite different in their attributes and mode of exercise. By virtue of its ultimate sovereignty over its own territory, every independent nation may at pleasure cede away a portion of that territory to a foreign power. That is interesting. That makes perfect sense, though, to me. I'm going to highlight that. A fortiori, I'm not even sure how to pronounce that. It may appropriate. Let me see. It may appropriate it to its own use. I wonder what is that. I'm going to look up that term. Give me a second. I'm going to look up that term. What's that term called? Fortiori. Let me see. Fortiori. That means from the stronger arc. Okay. The term is used when drawing a conclusion that's even more obvious or convincing. Okay. I can kind of understand why they said that. But let me look at the legal definition. It probably means the same thing, though. Signals an argument that is based upon an even stronger argument. In Latin, the term literally means from the stronger. Hey, how do you pronounce that, though? Anyway, let's get back to the case. A fortiori, or whatever how you pronounce it, it may appropriate to it to its own use. Oh God, I got a headache. Oh, I get like this when I have a headache. When I've been reading too long, this is how I get, y'all. This power of cession to a foreign country is prohibited to the states of our union by the federal compact, but the right to appropriate its own territory to the public use remains intact, limited only by clauses in their several constitutions, similar to the one under discussion, providing that the private owner shall be compensated therefor. In taking the property of the citizen for its own use, the state exercises what is known as the right of eminent domain. It is evident, therefore, that the clause of the Constitution under review applies to this power. Does it apply also to the power of taxation? In imposing taxes, can the state be said to take property of the citizen for public use? I say they can because you're taxing it. I'm of the opinion that they can. Matter of fact, that's what this case, let me show y'all this case right here, what I was talking. That's what this case is talking about right here. They're gonna, where's that question at? Here it is, right here. The question is, had the legislature the power to subject the defendant's property to taxation for the corporate purposes of the Monroney City by thus extending its limits? That's the question that they're going to answer in this case right here, the Utah case right there. In some sense, perhaps it may, but not, we think, in the fair and common acceptation of the words. If taxation is the taking of private property for public use, and therefore must necessarily be accompanied by compensation, this latter is received only in the protection which government gives to life and property, and to the increased value of the latter by reason of that protection. But it is held in this state that under the clause of the Constitution, under consideration, the compensation must be in money and nothing else will meet the requirements of the organic law. That might be why they're ruling the way that they're ruling then. It is also held in the same cases that the compensation must be paid or tendered in advance, yet in most cases of taxation for public works, the collection of the tax precedes the inauguration of the work. It would seem, therefore, that if this clause of the Constitution applies to the exercise of the taxing power, the construction of it, as settled in this state, is constantly violated and must, in the nature of things, continue to be perpetually violated in the future. Excuse me. It is, however, expressly decided, what is that? Carmack versus Williams, I'm not sure which so-called state that is, that this clause does not apply to the taxing power. It seems settled also, we think, by what we regard as the weight of authority in other states, that the requirements of compensation to the owner for property taken is not a limitation upon the exercise of that power. Let's see. There are a series of cases in several of the states holding a different view from that here announced. In Iowa, Kansas, Kentucky, and Nebraska, there are quite a number of cases strikingly analogous to the one at bar in which the relief here prayed for was granted. They are much pressed on our attention by counsel, and it is quite evident that they afforded the groundwork for this appeal for judicial what in the world was that? Interposition against the legislative injustice. These cases hold that while the enlargement of municipal boundaries and the consequent imposition of municipal taxes upon the property of unwilling citizens is not ordinarily such a taking of private property for public use as violates the Constitution, yet it may so operate if the extension is unreasonable and embraces territory not needing for building or population, and which it is held by the owners not for sale or use, not for sale or use as city lots, but purely for agriculture or horticultural purposes. I don't know what that term is. Horticulture. Let me see what that term is. Horticultural. Let's see what that is. Branch of plant dealing with the garden of crops, generally fruits, vegetables. Okay. Okay, so I see what that is. All right, that's cool. That's dope right there. Learn something new every day, y'all. Let me check the chat. What's good, AC? I'm gonna put the number back in the chat just in case y'all want to see it. Y'all can call in to the. I'm reading a case right now. I'm reading a case right now. This is a pretty good case. Even though I think that what they're saying, they're probably gonna rule against this guy. This may have changed. This is an old case, so it may have changed. But I know I'm convinced that if they're gonna tax private property, then that constitutes a taking, in my opinion. but they're going to explain the reasons why they say it doesn't. We have given these decisions the consideration that the importance of the principles and the high character of the tribunals announcing them demand in our hands. But, however strongly impressed with their natural justice and equity, we cannot consent to follow them as affording ground for judicial no, for judicial norming of legislative action. Municipal corporations are mere creatures of legislation of legislative will, established or abolished at the pleasure of that body in which the legislative power resides, as its conception of the interests of the state's demands. So let me tell y'all what this means. The reason why they're saying that is because the legislative created these municipal bodies. So if they're going to say that, then can't you reasonably conclude that since the people created the Constitution and the Constitution doesn't apply to them, that they can change that Constitution whenever they want, in every manner that they want, that they can write the legislative body of government out of existence at will whenever they want because they created it? Is that Does that not mean that? Because I'm of the opinion, and I'm 100% sure that that is exactly what that means, even though they don't say it in here. In their creation or abolishment, the legislature is under no legal compulsion to consult the wishes of the inhabitants of the municipality. So what this means is you are under no legal compulsion to consult the wishes of the legislative branch of government if you want to write them out of existence, or if you want to limit their power more than what it's already limited to, because you created them, the people created them. However, much wise statesmanship and natural justice may dictate such a course. Their charters are altered or repealed, and their bodies contracted or enlarged at the will of the General Assembly, which is the legislature, either with or without the consent of the persons affected thereby, as the legislature may see fit. Same thing goes for you. You have plenary power. The people have plenary power over every branch of government. Every branch of government. In the absence of some specific constitutional limitations, the power of the legislative department in this regard is absolute and uncontrollable by the courts. Okay, so we're gonna say this: in the absence of some specific constitutional limitations, the powers of the legislative department in this regard is absolute. Okay, so what they're saying is they have plenary power. Like I just said, we have plenary power over every branch of government, and we do, because you're sovereign and they are not. And the cases, they're cited, blah, blah, blah. Let's go down. Most of the cases relied on by the appellant recognize the force of these views, which are not indeed anywhere seriously disputed, but they undertake to draw a distinction between the power of the legislature to create municipal corporations and the right to delegate. Did y'all hear that? The right to delegate to these bodies the power of taxation. So if they have the right to delegate, or in other words, to authorize these municipal corporations to tax you, then they have to be able to enforce their right to tax you. How do they do that? They do that by creating administrative agencies, aka inferior courts. And they do that by clothing or by authorizing these executive officers of these administrative agencies powers that are of a judicial nature, despite the fact that the legislature does not have any judicial power. That is what they are doing. They do this to enforce their public rights. That's all they adjudicate is public rights. Let me go and check the chat. No, AC. When I say the Constitution does not apply to you, I mean this. The Constitution does not say what you can and cannot do. So if the Constitution, which is the supreme law of the land, does not prohibit what you can and cannot do, and the Constitution is superior to a statute, then how can a statute determine what you can and cannot do? You can't violate the Constitution. I can't violate the Constitution unless a sheriff comes along and say, "Hey, I need you to help me arrest this guy," or something like that. And if we go in and we arrest the guy, whatever, and it's an unlawful arrest, then yeah, you can be held under 42 Section 1983. But you cannot sue a private citizen under 42 Section 1983. You can't do it. Let me get a drink of water, y'all. Read John Dillon Home Rule. It applies in all states. We state the same as you are. Okay. Appreciate that, Gary. Home that municipal corporations such as counties and cities are mirror creatures of the state. Yeah, that's what they are, and could exist only those powers delegated to them. But yeah, that's right. That's absolutely right. They're territories. They are political subdivisions. Political subdivisions are territories. That's why the legislature has plenary power over them, just like Congress has plenary power over the territories that are subject to the United States Congress. Just like you have plenary power over all of your private property. Let me go and check the phone lines. All right, we got about an hour on the phone line. Y'all can call in or whatever you want. Let me get back to this case. Where did we leave off? Okay. It is said that the courts may restrict the one, but may control the other. Hence, it is asserted that while recognizing the power of the General Assembly to prescribe such boundaries as it chooses for cities and towns, the courts will limit the exercise of the taxing power of those local governments within such boundaries, inside the lines of the incorporation, as to exclude from its operation all property not benefited by the municipal government. All right. So essentially, what this is what people do in municipalities. They all come together and say, you know what? Let's put all of our resources together. But we know once we do this, our sovereignty is going to be limited, and as a result of our sovereignty going to be limited, and we're going to appoint public servants over us, to do certain things. We are no longer living in a republic. We're going to go to a democracy wherein the majority of votes of the people within this corporate territorial jurisdiction votes. The majority of whatever they vote for will come to pass, and so on and so forth, like that. They have every right to do that, y'all, just like you have every right not to participate in it at all. And as a result of them, forming this democracy, they're gonna say, okay, well, look, we'll let you tax us. Okay, we don't have a problem with the taxes. Um, but just so long as our taxes are for our, for our streets, for our schools, for if we get hungry, food stamps, something like that. Is this making sense for y'all? All taxes, generally speaking, are conditioned on a benefit. If they are not rendering you a benefit, they cannot tax you unless you just don't have a problem with it. A license is a tax too, by the way. Let's go down. Thus, it is said that the courts will examine city maps and surveys and hear proof as to the location and uses of the particular property in question. And if it appears that the proposed extension of the corporate limits embraces lands exclusively used, meaning lands that is used only for agriculture, horticulture, or mining purpose, or mining purposes, the imposition of municipal taxes thereon will be enjoined. So let's go and see what enjoined mean. They're going to stop them from doing that. Enjoined. We're in equity now, y'all. This is why you need to go and read in a law dictionary. I do not assume you know the meaning of these words. Enjoin is the verb form of the term injunction. So they're going to prohibit them, which means prohibit someone from doing something by issuing an injunction. In other words, a court enjoins something when it issues an injunction against it. That's what they're going to do. These decisions have all been made upon cases arising under amendments to charters and extensions of limits. No distinction is perceived by us between an old and new charter in this respect. Complainant asserts in his bill, in this case, that there are that there are within the limits of an old incorporation of the city of Natchez several hundred acres of land wholly unnecessary to and unused for any urban purposes whatever, neither mapped off into lots nor intersected by streets. May the owners of this property enjoin the imposition of any municipal taxes thereon. If not, what different principle authorizes complainant to do so? Good questions, good questions. But if they may, are the courts to enter into perpetual inquiries as to what benefit is received by each and every inhabitant of an incorporated town from the local government thereof? No principle could be more dangerous and, in judicial inquiry, more uncertain and unsatisfactory. The advantages derived from an urban government are frequently difficult to point out, and may indeed be wholly illusory. It is, for instance, quite fashionable in this state to incorporate under high-sounding names every collection of a half-dozen houses erected at the intersection of the county crossroads. The limits of these fictitious towns and cities frequently embrace quite an extensive area of land. Y'all, what this means is these are legal fictions. That's what they are. No advantage visible to the eye is thereby conferred upon the property or its owners. Neither streets nor sidewalks, nor gas lights, nor waterworks greet the traveler or minister to the comfort of the inhabitants. Shall the courts therefore declare that the legislature has violated the organic law in their creation, or enter upon an investigation as to the amount of benefit received by each particular piece of property embraced therein? I think they should. I know that's a lot of work to do, but if you don't want to do it, then you don't need to be sitting in that seat. All right, because this is we have a dispute right here. There are public rights and private rights, and they're in dispute. Admitting, as the decisions relied upon by complainant do, the power of the legislature, of the legislative assembly to organize these inferior local governments and to delegate to them the power of taxation for municipal purposes, we are unable to perceive any sound principle which can authorize the courts to sit in judgment upon this legislative will and to declare what property ought and what ought not to have been included within the corporate boundaries. I disagree with that. But let's just read the case. Or to say what property so embraced shall and shall not bear the burdens of the local government. The assumption of such power by the courts we regard as alike unsound in theory and dangerous in practice. Mr. Cooley, now I've read a lot of cases, these old cases, and this man must be some sort of guru, because like I don't care I don't care which state it was. I like a lot of them cite this guy, Mr. Cooley. So Mr. Cooley must have been a cool man. He must have knew what he was doing. Mr. Cooley, alluding to this class of decisions, after stating the conclusions reached in them, remarks that it would seem as if there must be great practical difficulties, if not some of if not some, if not some of principle, in making this disposition of such a case. Know that, right? While the practical difficulties alluded to by Judge Cooley seem to us so grave as to be, in effect, insurmountable, we will not say that a case may not arise which would call for judicial interposition, as, for instance, if the limits of a town or village were so extended as to embrace an entire county or a circumference of 10 miles. So I think the reason why they're deciding to do this, like, even though I disagree. I think I lost signal. All right, y'all. Let me see what's up. Okay. Am I still live? Can y'all still hear me? Cause I think I lost a connection, so I had to stop. Can y'all still hear me? Can y'all still see the screen? Everything's good. I'm gonna wait on y'all to respond. Okay, so you still can. Let's see, man. Okay. All right, cool. Okay, let me go back to the case. Let me go back to the, if y'all have any questions about the case, let me know. All right, just let me know. Where we at? Gotta figure out. Okay, we stopped at about right here. Without undertaking to say what would be our decision in such a case, we prefer to confine ourselves to the case in hand and to declare that we cannot undertake to enjoin the legislature to enjoin the legislative will in this case because it has seen fit to extend the limits of the city of Natchez 600 yards further than seems to have been demanded by the circumstances of the city or by the wishes of the inhabitants within or without the boundaries. Okay, I can understand that, but still, I mean, 600 yards, I can understand that. Let's see if they're going to give him his remedy, though. All right. The relief for the injustice thereby done, if any, has been done, must be found at the ballot box operating on the legislature and not through the courts. I strongly disagree with that. It is not for us to define the limits of the legislative discretion. I agree with that, nor, in the absence of constitutional limit, to declare laws void because, in our opinion, they are morally wrong or practically unjust. Let the decree dismissing the bill be affirmed. So they dismissed it. So he didn't get his remedy. He didn't get his remedy. Um, so he's saying he's supposed to vote. I strongly disagree with that, but that's how they do it in Mississippi. All right, that's how they do it in Mississippi. Now, this case right here, this case holds that the taxing of private property that is without, meaning outside the corporate territorial jurisdiction of municipal corporations, is a taking of private property for public use without just compensation. And I agree with that. That's what this case holds. So if they're taxing private property, but they're not rendering you any benefits, then they violating due process. And I'm pretty sure this happens everywhere. This happens everywhere. So again, these cases are extremely old. These are the cases that lay the foundations for the cases that we have today. All right, so this is why y'all need to go and read old cases. Sometimes, read new cases too, but they like these old cases. They just tell you what it is, man. They don't really sugarcoat anything. They call them corporations, corporate charter, so on and so forth, like that. Now there was another. No, I gotta find that case. I saved it, but I gotta find it. I think it's. Let me see if I can find it. It's called. Let me see. Deem. We gotta go here. I'm hungry. Man, I'm hungry. deem. What is that? Territorial jurisdiction, reverse equity, not that one. Judicial power on executive officers, that's not it. That's not it. Promissory note, that's not it. That's not it. I'm gonna have to find that case again. I'm trying to find it, y'all. Give me a second. The Supreme Court, Volume 27. That's not it. Is this it? Child support. Nope, that's not it. Unconstitutional corporate city. I don't think that's it either. That's not it. Dang it, I gotta find that case. But what happens is, if you're in these, I gotta show y'all that. I'm gonna find it again. They're going to, if you live in a municipality, they're going to deem you as a corporator of that municipality because you're living out there, and they're just going to say you acquiescence to everything pretty much that they're doing to you if you live out there, even though you are not a shareholder in that corporation. You had um no connection to it being formed. It's an old case, but that's exactly what they say. It might be this case. I don't know. I think it's another case. But let me go to the chat and see what's up. Yes, you're good. Okay, just getting on. Good. Okay. Let me go to the phone. Okay, we have about 56 minutes, so you can call in if you have any questions. You can call in or whatever. It doesn't matter. This is a good case. I'm gonna still save this case though. This is a pretty good case. Let's see. Tax private property. We're gonna say territorial jurisdiction. We're gonna make sure we want to say corporate. I gotta find that case. I got to find that case. Deemed a corporator. Let me see. I might be able to find it. I really want to show y'all that case. That was a good case. Yes, for corporation. Deemed corporator. Municipal corporation. I don't think I put any of that in now. Let me see if this is it. Tax uniform on his land is to take his private property for public use without just compensation, whatever, and therefore, it's a Georgia case. Look how old. Look at this stuff, y'all. Just look at it. It's crazy. All this stuff is here, though, man. It's all here. Shall accompany the territory and property and jurisdiction. This Georgia case looks pretty good. I'm gonna click on this Georgia case. See how long it is. The question of taxation is one of power, and exercise of it is vested in the lawmaking department of the government. Let's see how long this case is. 8 pages. Okay, we can do 8 pages. We can do 8 pages. All right. Let me give y'all that case citation again. Okay, this is a Georgia Supreme Court case from 1875. Again, if you enjoy it, it is, man, look, if y'all don't want these people to tax you, it is your right. I mean, not your right. It's your responsibility to know this stuff, man. This is our fault. You got to know your rights. You have to know your rights. This is the website you need to come on and read these old cases. I'm going to post this case into the chat section. So if y'all want to click on it and read it and download it and all that, you can. Hit PDF, and it's going to let you download it. We can do 8 pages. Geographically speaking, Australia and Commonwealth of Australia includes Norfolk, Christmas, and Coast. Okay, that's interesting. So it seems like you can't buy and own land outright, or is that possible? Well, I'm of the opinion um, that you can. However, I'm also of the opinion that you can't. And let me tell you why I say this. There is no money. Ain't no money. So generally speaking, you can't buy nothing. But they're not going to tell you that there is no money. So you mean to tell me if you go down there and you get these people $20,000 so-called in Federal Reserve notes, if they're going to tell you that that is not money? No, they're not going to. They're not going to tell you that that is not money. You can forget about that. They're not going to do that. All right. Um, they're going to hand over you. They're going to hand over you to. You're probably not going to get legal title to the property until you're gonna have to go through some sort of administrative process in regards to that. I'm not sure what the process is because I've never done it, but I kind of don't believe you even have to do that. So let's say you move into a municipality, not a municipality. Let's say you move out of a municipality and you move somewhere in a rural area. All right, that rural area, in my opinion, because counties have charters too. They're corporations too. They're municipal corporations. That rural area uh, may be within their corporate territorial jurisdiction so that they can tax it. So as soon as you move there, do not waste any time removing your private property from within their corporate territorial jurisdiction. I would send maybe a cease and desist letter or something like that to that effect. And just letting everybody know, letting all the municipalities know, hey, look, I'm over here. I'm the new landowner now, and I want to remove this private property from within your corporate territorial jurisdiction. All right. I'm not wasting any time to do that. I would really appreciate it that if you made this easy for me and not having for us to go to court and stuff like that. They may do it. Who knows? They may do it. If they don't, then I will petition for a writ of quo warranto to oust them from that because um, you're new. You're not accepting any benefits from these people. You see what I was just saying, reading in that case? If you start accepting benefits from these people as a result of you paying property taxes, it's a wrap. You're not going to be able to oust them from exercising their corporate territorial jurisdiction over your land. But keep in mind now, this is a rural area, so you're gonna have to build this up from the ground up, meaning your private roads, cities, town, whatever, everything private. You're gonna have to build it from the ground up, but you can do it. And what I would do is if I was successful at that, with ousting them from exercising their corporate territorial jurisdiction over my private property, my land, I would form me a business. All right. Get me an EIN number, probably get me a CPN number or something like that, a legit CPN number. And I would do business in that business name with that EIN number and that CPN number uh to generate to build my society, to build on my private land. I would establish some business credit. Go down to maybe Home Depot, Lowe's, something like that, and start building on my land. Get me some chainsaws, cut these trees down, sell the wood on the land. Uh, get me a tractor, dig me a little lake or something like that. Give me a second, y'all. I'll be right back. Let me go back to this. Where's that case at? Right here. Give me a second, y'all. I'm sorry. All right. Okay, let me get a drink of water, and then we'll go and read this case. Let me check the phone lines. I got. If you want to call in, you got 48 minutes, so you need to call in now. I'm gonna check the phone lines in a minute. I'm gonna read this case. These are principles. This is where they get all of their principles from, y'all. This is where they do it. This is how they do it. The judiciary is doing their job. All right, I'm of the opinion that they did their job, y'all. Back then, they're not. I don't know what they're doing now. All right, they obviously they just not doing it now. Let's make this a little bigger so everybody can see. All right, taxes, constitutional law, municipal corporations before Judge Rice, Clark Superior Court, August term 1874. This case is reported in the decision. So the plaintiff in error, so the plaintiff appealed. Private property not taken for public use without just compensation. Taxation on agricultural lands for corporate purposes should be enjoined. That is very interesting, but I can guarantee you right now that there's somebody who is just growing food on their land. That is all that they're doing, and they're not receiving any benefits from the city whatsoever. They probably don't live 30 miles within the city, within the territorial corporate jurisdiction of the city, and they're still being taxed on it. Probably the county is taxing them on it. All right. Let me see. And who is this? Cobb, Aaron, blah 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 for the defendant. Okay. So let's see. First, constitutional provision as to exercise a right of eminent domain has no application in this case. That's what they argue. Now I want y'all to keep in mind. Okay. Let me see how old that other case was. See which time frames is it? Because this case is from 1870. Let me go back. Oh, that Mississippi case. Let me go back and see. Downloads, tax. All right, right here, property tax. This is from 1876. This is the Mississippi Supreme Court case. Okay, so this is 1876. This case is, I think it was 1874. 1874. Okay, so this one was decided before the other case. So let's see how they ruled in the case, because these are two different jurisdictions. All right, and let's see what the outcome of the case was. It's probably going to be, it may be different. It's really just going to depend on the facts of the case. First, constitutional provision as to exercise a right of eminent domain has no application in this case. That's what they're arguing. General Assembly authorized to pass such law. Courts cannot control discretion of the legislature. All right, that's what they are arguing. Chief Justice Warner. This was a bill in equity filed by the complainant against the defendant, praying for an injunction to restrain the collection of a tax, let me see, of a tax execution issued by the defendant against the complainant's property on the ground that the tax is illegal. We'll see. When the motion for an injunction came on to be heard, the defendant demurred, so they don't want to talk about it, to the complainant's bill for want of equity. They're saying that his bill is inequitable. They're saying he's not entitled to any equity. The court sustained the demur and the complainant accepted. So he disagreed with it. He disagreed with it. And that's why they have this appeal. The complaint alleges that he is a former by occupation, and in order to carry on said occupation, he many years ago purchased a valuable tract of land in the county of Clark, situated about 1.5 miles from the center of the city of Athens, and is now engaged in the occupation of said land solely for agricultural purposes. That in 1815, the corporate limits of the town of Athens were extended and 1 mile in every direction for the college chapel. That in 1842, the limits of said town of Athens were extended to prevent the sale of liquors and the establishment of lewd houses in close proximity to Franklin College, situated in said town, and not for purposes of increasing the municipal revenue. That in 1872, the General Assembly passed an act amending the charter of the town of Athens, making it a city. the authority and jurisdiction of which was extended a distance of 2 miles in every direction from the college chapel. So they're annexing his property. Is in a sense that's what they're doing. They're annexing. They're seizing his property. So they're gonna have some sort of naked title over his property. Well, that's what they're trying to do. It will be noticed that the complainant does not allege in his bill what distance from the college chapel to the act of 1842 extended the corporate limits of the town, but by reference that the act, it appears that the corporate limits of the town were extended by it 2 miles from the college chapel, and the act of 1872 does not extend the limits of the city of Athens any further than the corporate limits of the town of Athens were extended by the act of 1842. Nor does the complainant allege at what time he purchased the land, but it was conceded on the argument that he purchased it subsequent to the year 1842. So he purchased it after the year of 1842. The complainant alleges in his bill that he is annually subjected to the payment of taxes of $99.10 on his land by the municipal corporation without deriving any benefit therefrom, as no let me see, as no part of his land is required for streets or houses or any other purpose connected with the municipal organization of the city of Athens. Let's see what we do. Let's see. But it is used by him exclusively for agricultural purposes, and that the result of the imposition of said tax on his land is to take his private property for public use without any compensation whatever, and therefore the law which imposes the tax upon his land within the corporate limits of city in Athens, within the corporate limits of the city, is unconstitutional and void. Let's see. The power of taxation is vested in the sovereign authority of the state. No constitutional government can exist without it. Its exercise is essential to the very existence of state government. As was said by Chief Justice Marshall in the case of the Providence versus what is it, Bank versus Billings. I'm assuming that this is maybe some sort of federal case. Let me go and check the chat right quick. Uh, let's see. Let me check these right here. Patents and grants. Man, this is a lot of. I'm gonna read these comments. Like, this is a lot of comments, y'all. I'm sorry. Uh, okay, where we at? It resides in the government as part of itself, and need not be reserved where property of any description, excuse me, or the right to use it in any manner is granted to individuals or corporate bodies. However, absolute the right of any individual may be, it is still in the nature of that right that it must bear a portion of the public burdens, and that portion must be determined by the legislature. This vital power may be abused, but the interest, wisdom, and justice of the representative body and its relations with its constituents furnish the only security against unjust and excessive taxation, as well as against unwise taxation. By the Constitution of this state, the power of taxation over the whole state shall be exercised by the General Assembly only to raise revenue for the support of government. All right, but if you're in a republic, generally speaking, you don't have a government. Generally speaking, all right, to pay the public debt, to provide a general school fund for common defenses and for public improvements, and taxation on property shall be ad valorem only. I wonder what that means. Ad valorem. We're going to see what that means. Not sure if I spelled that right. And I did not. Did I spell it right? Oh, we ain't got time for all that. Let me go and check this out and see what that means. Ad valorem tax. Ad valorem translated directly from Latin means according to the value of something. Okay. So they're going to tax you on only according to the value of it. Okay. In the practice use, the term is used in taxation to designate taxes levied against property, real or personal, to a certain rate based upon the property's value. Okay. All right. And uniform of all species of property taxed. The General Assembly may grant the power of taxation to the county authorities and municipal corporations to be exercised within their several territorial limits. Y'all paying attention to that? Not without their several territorial limits, meaning not outside. We'll see. There is no pretense that the land of complaint, which is taxed, is not within the territorial limits of the municipal corporation, and that it was within those limits when he purchased it. Ooh, interesting. Or that the rate of taxation is greater than is authorized by the charter of the city, or that it has not been assessed upon the ad valorem and uniform principle as required by the Constitution. But the complaint is that inasmuch as he has no use for the municipal government, municipal organization, and inasmuch as it is of no practical benefit to him, therefore, to tax his land $90 a year for the benefit of the corporation is taking his private property for public use without compensation, and therefore the law which authorizes the assessment and collection of the tax on his land within the limits of the corporation is unconstitutional and void. Tax laws, as well as all other general laws, sometimes operate harshly in individual cases, and we suppose always will, owing to the imperfection of human legislatures. A man living within the limits of a municipal corporation of large property who has no children to educate might think it hard and unjust that his property should be taxed to raise a school fund to educate others people's children. I gotta go. Let me go back to the chat. Is this all it? Is this stuff making sense for y'all? Because it is making so much sense to me. Is it making sense for y'all? Let me know if this stuff making sense for y'all. Give me a thumbs up. Give me something and just let me know that this stuff is making sense for y'all. Whew. Let me get me a drink of water, y'all. I'll be right back. Throat getting dry. I'm hungry too. Let me check the phone lines. All right, nobody called in yet. Nobody called in yet. Y'all know what? Every time I go live, man, not every time, but sometimes when I go live, I get maybe 3 or 4 calls or something like that. And then when I get all, like when I'm not live anymore, like I get all these emails asking for help. And I'm not live anymore. So you're going to have to pay me for my time then. But like right now, this is free. I'm on here 2 hours, sometimes 3, maybe 4, for free. And you're not taking advantage of that. Anyway, let's get to the case. Let's get back to where are we? All right, I think we're about right here. In these cases, as many others which might be cited, the individuals whose property might be taxed would have no more personal interest in the special object for which the tax was levied that the complainant has in the municipal corporation of the city of Athens and its organization. The question of taxation is one of power, and the exercise of it is vested in the lawmaking department of government. And when that department has exercised its judgment in relation to the assessment of taxes, the courts have no power to interfere on the ground that the tax is unfair or unjust unless the fundamental law of the land has been violated. They're talking about due process, I'm assuming. The collection of all taxes is, in a certain sense, the taking of private property for the use of the public, and the case made, and the case made by the complainant does not constitute an exception to the general rule. So he's saying, the complainant who's made this case, um, the General Assembly does not qualify for an exception for their taxing his private property to not constitute a taking of private property for public use. That's what they're saying, if that makes sense, because it makes perfect sense to me. I'm gonna read it again. Where are we at? Right here. The collection of all taxes is, in a certain sense, the taking of private property for the use of the public, and the case made by the complainant does not constitute an exception to the general rule. I think this, let me read a little bit more. Okay. Taking his property, taxing his property within the limits of the city of Athens, within the limits of the city for the benefit of the municipal corporation is no more taking private property for the use of the public than the taxing of a man's property who had no children to raise a fund for the education of other people's children within the corporate limits of the city would be the taking of private property for the use of the public. It is nothing more than the exercise of the sovereign authority of the state, its legislative will upon the subject of taxation, an inherent power which belongs to the state. It is true that this general power of taxation may be abused by the lawmaking power of the state, but the remedy for such abuse is in the vigilance of the people over the conduct of their representatives in making extravagant expenditures and taxing the people for the payment thereof. So they're saying that the people have to do something, but you're not collaterally stopped from ousting them from exercising their corporate territorial jurisdiction over your land. You need to go to some sort of if you're going to do this, you need to move out to a rural area. All right, that's what you're going to have to do. You're going to have to move out to a rural area. By the Constitution, the General Assembly of this state have power to make all laws and ordinances consistent with the Constitution and not repugnant to the Constitution of the United States, which they shall deem necessary and proper for the welfare of the state. In 1842, the General Assembly deemed it necessary and proper to extend the corporate limits of the town of Athens 2 miles in every direction for the college chapel. Okay. Whether this was done for the benefit of Franklin College or for other reasons satisfactory to the lawmaking power, it is not material to the inquiry. So they're saying it's not a deciding factor. In 1872, the General Assembly, in amending the corporate charter, confirmed the extension of the corporate limits of the city as to the same existed by the Act of 1842. The Act of 1872 did not extend the corporate limits of the corporation so as to embrace more territory than was included by the Act of 1842. By the Act of 1872, the mayor and city council of the city of Athens had full power and authority to levy and collect an annual tax of not exceeding 1% upon the value of all property within the corporate limits of said city, of whatever kind, real or personal, which is or may be subject to taxation by the laws of the state. But I want y'all to pay attention that they can only tax what is within their corporate territorial jurisdiction. They can't tax it if it's outside it. Let me go and check the chat right quick. Okay. All I don't want to throw off the topic. We on my child support stuff, so I'm leaving. Okay, okay, cool, cool. Let me check the phone lines. All right. Well, when I finish reading this case, we could talk about that a little bit if you want to, AC. Where am I at? Uh, the complainant's land was within the corporate limits of the town of Athens when he purchased it, and is now within the corporate limits of the city of Athens under the amended charter. It is not pretended that the tax assessed on the land is more than 1% on its value, or that the land is not within the corporate limits of the city. Yeah, he should have argued that way. I don't think he argued his case right. But anyway, that really shouldn't affect how he won it. I mean, how his case. Well, yeah, I take that back. It does, because what you say does matter. So I take that back. Yet this court is asked to declare the law imposing the tax on the complainant's land unconstitutional and void because he has no use for the corporation and it is of no benefit to him, and to require him to pay the tax in obedience of the laws of the state will be to take his private property for the use of the public without just compensation. Uh, the reply is that the sovereign authority of his state has declared by her constitutional legislative enactment that she deems it necessary and proper for her welfare that she should pay the tax assessed upon his land, and therefore it is his duty as one of her citizens to pay it, whether in his judgment he will be benefited by its payment or not. If each individual taxpayer should refuse to pay the tax imposed upon his property by the sovereign authority of the state, because in his judgment he would not be benefited by its payment, there would not be much tax money collected. Several cases decided in some of the western states of the Union were cited on the argument by the plaintiff in error. The principle decided in those cases is that although the courts do not hold the legislative enactment imposing the taxes to be absolutely void, but only hold that the courts have no power to limit the exercise of the taxing power of the state, when in their judgment upon a given set of facts, the individual whose property is taxed derives no benefit from the object for which the tax is imposed, then they will enjoin the collection of taxes. In other words, the practical effect of those decisions is for the courts of the state to assume and decide what taxes are necessary and proper for the welfare of the state. And I agree with that. So what they're saying is, since this man he has no use and no benefit for it, why is he paying his share? Why is he paying a share of the tax if he's not going to use any of the benefits of the municipality, of the corporation, instead of the legislative department of the state government? Coolly on constitutional limitations. Look at this. I just told y'all they're talking about this guy again, man. Cooley again. I just read about him in the other case. And this is a Georgia case, but they cite Cooley again. Cooley must be one bad man, man. After citing several of those cases, remarks in a note that it would be let me see, is this the right case? Yeah. It would seem as if there must be a great practical difficulty. Are they citing the same thing? I think I just read this in the other case. I believe I did. Difficulties, if not of some principle, in making this disposition of such a case. Let me see. Maryland Chief Justice Marshall. It is unfit for the Judicial Department to inquire what degree of taxation is the legitimate use and what degree may amount to the abuse of power. By the Constitution of this state, the legislative, executive, and judicial department shall be distinct, and each department shall be confided to a separate body of magistracy. What is magistracy? Because all of them are magistrates. Let me show y'all what it is. All of them are magistrates. A magistrate is a judge who has blah, blah, blah. Yeah, you can say a judge is a magistrate. In the federal court system, magistrates are judges. I'm trying to find the general sense because I want y'all to understand what a magistrate is. Uh, it's not gonna. I'm gonna have to go into another law dictionary, and I don't have time for that. But a magistrate, generally speaking, a public servant is a magistrate. Generally speaking, no person or collection of persons being of one department shall exercise any power properly attached to either of those others, except in cases wherein expressly provided. Y'all paying attention to that? So they can do it, but they can only do it over over something that they have plenary power of, meaning they can only exercise plenary power over something that they create. It follows, therefore, that in this state at least, inasmuch as the power to levy and collect taxes is vested in the General Assembly, that it would, in the language of Chief Justice Marshall, be unfit for the judicial department of the state government to inquire whether the lawmaking power of the state has acted wisely or unwisely, justly or unjustly in taxing the property of the complainant as set forth in the record. The principle involved in the case now before us was decided in the case of Frederick versus City Council, August, Georgia, blah blah blah. In that case, this court held that when the lawmaking power acts within the scope of its delegated authority, the courts cannot interfere. It is the duty of the judicial tribunals of the county to execute and enforce all constitutional laws and not to make them. The remedy against the effect of oppressive legislation delegated by municipal corporations is in the hands of the people or their representatives. But the argument for the plaintiff in error in the case now before us, as we understand it, is that the tax upon the complainant's property is not, is not unconstitutional because it is unjust and oppressive, but as the municipal corporation of the city of Athens, which he is taxed to maintain, is of no benefit to him. It is unjust and oppressive to compel him to pay a tax on his property for its support, and therefore the law which compels him to do so is unconstitutional because it take because it take his property for the use of the public without compensation. The reply is that the tax of the property within the corporate limits of the city of Athens was a question for the legislative department of government to decide and not a question for the courts. We find no error in staining the demur to the complaint's bill. Let the judgment of the record below be okay. So that he didn't get his remedy. He didn't get his remedy. You got to get out of there, man. You got to get if you don't want them to tax your price, you got to get up out of these municipal corporations. You got to get up out of there, and you got to be mindful and watchful of your property. But again, now, if I'm not mistaken, this case says they can't do that. They consider it a taking. All right, and this is from 1889. All right, so it just depends. I guess it depends on where you are. Um, double entry, accounting entries. Let me see. All right, let me go and read some of these comments. Let me check the phone lines right quick. I got 19 minutes. You can call in if you want to. I'm getting a headache. Like I literally got a headache, y'all. Where's that number at? If you haven't already, go ahead and register for my juror membership. 99 cents. I put the phone number in the chat, so if you want to call in, you can call in. All right, let me read some of these comments. All right, I'm gonna read everybody who is a member of my juror members comment first. You get priority. So I'm gonna read all these and I'm gonna give you some comment, some feedback on them. So let me go up and see. Okay. It's all fake. Let's go. Okay, I know I was considering buying a plot and reselling it immediately to my wife for gold, but I'm new to this and don't understand. So yet, excuse the ignorance. It's cool, man. That's cool, AC. It ain't no problem, man. Ain't no problem. How long have you been studying law, AC? How long have you been studying? It's okay if you don't understand. All right. But if they ignore, then they acquiescence. No silence is agreement. Yeah, that is correct. So they look at it as um they base it on your conduct and not really on what you say. So if you don't want them exercising their corporate territorial jurisdiction over your land, you need to act immediately. You do not need to wait at all. But you're in a municipality right now, and you just I mean the only ones who can change that right now is the people in this municipality, and that's obviously not going to happen because first of all, people they don't even know that they have the authority to do this. The people they don't even know that they have the people living in the municipality. They don't even know that they have the authority to do this. You know what I'm saying? Not only that, um, you need a majority of the people within that corporate territorial jurisdiction to agree with you. And that people are like some generally speaking, people are just brainwashed. That's going to be very difficult for you to do. So you're just better off just leaving the city. I would not. I live in the city now, but once I get my so-called money right, I'm getting up out of here. Period. I'm not going to own anything in the city except a business. I'm not going to come to the city for any other reason except business. And if some of my family is here, I'll go and see some of my family. But I'm not living out here. I'm leaving. Um, all right. If you want your comments answered, you need to subscribe to my membership. My jury membership is 99 cents. Then wouldn't you have legal right to go above their heads? Sorry, I'm trying to understand because child support used my silence to enforce my contract, but you can't. I don't really understand your question, AC. Can you call in, AC? We can talk. You can call in. We got some time. Call in. I'm here listening. I don't want to throw off. Okay, I got you, AC. I am only familiar with law through my experience, not studied at all. That's okay. You got to study, man. You got to study. Yeah, I was talking about land taxes. That's what I'm talking about. Let me go here right quick because I'm gonna keep throwing this out here. All right, join my juror membership. It's 99 cents. This is how you do it. You go to the community, well, not the community section, but you go on my YouTube page. You hit join. All right, click on the one you want, whatever, it don't matter. And you just hit join, and then you put all your card information in or whatever, and that's it. And I would really appreciate if y'all did that. Ooh, I'm tired. Let me go back. Okay, let's get back to it. I put the call in number in the chat if anybody wants it. I'm gonna check the phone lines. I'm checking the phone lines from time to time. One wise lady, you funny. I have no idea how to call in from down here, but you'll need an hour once I get the cackling here, get the cracking here. That's funny. That's funny. Y'all make sure y'all hit that like button too. $1.49 in Aussie dollars, not your worth. Way more than that. I'll just be a jury member once I get my card sorted out. All right. Thank you. I really appreciate that. Thank you. Um, okay, let me go and read some of these comments up here. All right, I did a live earlier where y'all able to understand like how to draft a motion? Because generally speaking, you draft all motions, all writs, all petitions, what else? appeals, briefs, whatever you want to call it. Generally speaking, you draft all of this stuff the same way. It's all the same. All of it is the same. Some silver gaffer tape now. Okay. Yeah, I was talking about land taxes. Yeah, yeah. So, I really didn't know all of this stuff in regards to taxes until I started reading these old cases, and I think I maybe only read about 3 or 4 old cases in regards to property taxes, and I mean they pretty much they tell me a lot. They tell me a lot. So basically, what you're paying these taxes for is just benefits. That's why Yusuf L says you only taxed on benefits and privileges. That's it. So if you're out in a rural area, you're probably not taxed at all. Well, I take that back. If you're in their corporate territorial jurisdiction, you're probably going to be taxed a little, but you're not going to be taxed as much as if you were in the city. What is this? Um, oh, that's that long case. Yeah, that's that long. That long. That's an extremely long. Look at this. Cooley Constitutional Law Limitations 30. Everybody's citing this guy, man. Judge Cooley. And this is from another case from how long? How old is this case? Let me make this a little smaller. I'm sorry about that. That's too big. This is from 1898. 1898. All right. Let's get back to the chat. All right. Before I go, I'm getting ready to get off here soon, y'all. I'm gonna get off here probably about 7 o'clock. I have about 12 minutes until 7 o'clock. So, so y'all go ahead and get all your questions out right now, man. Any questions? If not, I'm just gonna start reading another document. I'm gonna get into this document. Well, no, not this one's 14 pages. I want to find that document about the municipal corporate. I gotta see it. Let me see if I can find that document. That was a good case. It might be in? Is it gonna be in here? It's probably gonna be in here. What is this? I'm looking. All right. How old? Let me see how long this case is. I might read some of this one because I really be wanting y'all to see this stuff, man. Public services belong to the public. Yeah, that's interesting. That is a good case right there too. Man, that's a good case. Territory, not that one. I'm looking. Private property reversed. I'm looking for this case, y'all. Alabama Corporation. I don't. Is that it? Let me see if that's it. I don't think that's it. No, that ain't it. That's not it. Um, legal title. I don't think that's it either. Promissory note. That's not it either. Contract case. That's not it. I can't find that case. I'm about to find that case. That was a good case, y'all. Good case. Was it? Was it? I don't think that one was it either. Child support. What is this? 5/19/27. I'll read that one later. Let me go. Let me go and check the chat right quick. Where is it at? I wish I could find that case. Man, I wish I could find that case. It was a good case, y'all. save this one too, because this was a good case. Tax private property. All right. Let me see if I can find. I gotta see if I can find that. Man, if I can find that case, municipal corporation, territorial jurisdiction, deemed a corporator, deemed other involuntary municipal corporations. Two distinct municipal corporations have the same power privileges. Neither can encroach upon the territorial jurisdiction of other. That's not it. Deemed corporator. Let me see if this is it. Territorial corporation created by the territorial legislature of Colorado is not a federal corporation. It cannot. I can't find it, y'all. I'm gonna have to do it on my own time, because that was a good case. I saved that case, but I don't know where it's at. Jersey Hutch territory. This the next time I come on and do a live, I'm gonna do this case right here. I can't find that other case. Is this it? Unconstitutional corporate city charter. It might. Let me see if this is the case. I don't think this is it though. No, because I ain't saved nothing in here. That ain't it either. The case that I'm about to pull up is that case is crazy, man. Let me go back here. Not that. That's not it. I think it's an Alabama case. That's not it. Right here. This is 14 pages. This case is very interesting because in this case, they did not have this was back then where they didn't have cars. All right, but they're calling a coach or a wagon that is drawn by horses a vehicle. That is very interesting to me. They're saying it's a vehicle, and they're gonna call it a bus and all that. I'm not gonna do this one today. I'm gonna find that other case. When I find that other case, it's gonna be relating to municipal corporations. But anyway, back to the topic of the video. Uh, Again, y'all, that's why I say this is our fault. We need to know our rights. It's not nobody else's responsibility. It's ours. You have all of these old cases that you can be going back just like me and reading, no matter where you are, you can be going back and reading these cases. So if I were you, this is just me speaking. If I were you and I was in, let's see where we at. And if I was in Alabama, Georgia, whatever, I'm just gonna click on the first one I see. What is this? If I was in Utah, this is what I would do. I would go and read all these cases. I would take my time and read these old cases, starting with the first volume. In Utah, starts at 1861. So if you're in Utah, these cases go all the way back to 1861. and they have 123 volumes. This is the Utah Supreme Court. All right, 123 volumes. This is just the first volume. Look at all these cases in the first volume. Let's see what we get. Let's just randomly click on a case and see what it's about. Change of venue, appeal from District Court of the 3rd Judicial District. The bill was filed. It's probably some equity or something like that. Baskin fact. 4,000 cases. Let's go. Let's see what the first case was about. How long is the first case? Powers of a grand jury in the district courts. A grand jury summon from 12,000. I might need to read this case because this might be talking about principles. Organization of the territory, up to and including the term 1876, the people, blah, 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 versus Monroe Green, 7 pages. A grand jury summon from the body of the judicial district in which the court is held has the right to inquire into the violations of the territorial criminal laws coextensive with the district. Sans OBS connect. I think I'm gonna read this case. I'm not gonna do it today, but I'm gonna read this. All right, let's get back to the live. All right, look, y'all. Let me check the phone lines right quick. All right, so nobody called in today. That's even better for me because I really didn't even feel like talking. All right. I'm going to go ahead and I'm going to end the live.
90 seconds.
Yeah, I'm going to go ahead and end the live, y'all. Hopefully this, you learned something in this video. Hopefully you did. Excuse me. Go and read these old cases, y'all. Go and read the old cases. Let me save this case that I just found. Where is it? That's not it. Where is it? Right here. Okay.
60 seconds.
We're going to say common law grand jury. This is how I save cases that I'm interested in and I want to read. This is the first Utah Supreme Court case. The first one, at least, well, the first one that they've recorded, that they have on the books. All right. For the crime of an assault with an intent to kill and murder, one Nathan Tanner, and upon the trial was convicted and sentenced to imprisonment for the term of 6 months. The indictment contained 2 counts and the defendant pled not guilty as to both. The verdict is as follows. Anyway. All right, y'all. Let me get off here. I'm tired. I got a headache and I'm hungry. I'm definitely learning from you. I'm gonna email you for
10 seconds.
All right. You can look in all my videos and it'll tell you how to reach me for consultations, AC. So we can just go from there. All right, but I do appreciate everybody's support who has signed up. Again, let me show y'all again. Go here to support my channel, hit join, hit jury members, and hit join. All right, I really appreciate that. It's 99 cents. I get 70% of that. YouTube gets 30%. I really appreciate it. I have 2,030 something subscribers, and I don't even have 10 jury members on my channel. Can y'all believe that? 10. Anyway, that'll be it. I'm tired. The Supreme Litigant is out. Everybody enjoy your weekend. Be safe. I'm out. Peace. How do I end this live?